Good afternoon, everyone. Thank you for joining us. My name is Maria Madrid with the Colorado Gerontological Society. Today, we are going to cover legal guardianship and conservatorship as part of our advanced care planning webinar series. So a note before we begin, like I said, this is an advanced care planning webinar series. So all the webinars work in conjunction to give you a comprehensive look at advanced care planning. The information that we're covering today is Colorado specific. There's a lot of information that could be similar in other states, but every state has their own rules, regulations, statutes on advanced directives, legal guardianship, conservatorship. So once again, this is Colorado specific. The Colorado Gerontological Society provides free assistance to complete your advanced directives. So if you need assistance, please don't hesitate to reach out to us. Our website, senioranswers.org, has all the information that we are going to talk about today. Also, this webinar is being recorded. I will make available the recording in PowerPoint, as well as any other resources referenced in a follow-up email. And this webinar will also be available on our YouTube for you to watch as many times as you need. And today, even though the society focuses on older adults, we're encouraging advanced care planning for everyone 18 years of age and older. So right now, we're at the legal part of advanced care planning. In previous webinars, we've covered the medical and the financial aspects, and today we're focusing on one of the legal aspects. So our objectives for you today is for you to understand what is legal guardianship and conservatorship, when are they appropriate, what are best practices to follow, and very importantly, what are the duties, responsibilities of legal guardians and conservatorships. One of the things that sometimes we oversee as we're talking about advanced care planning and having a plan for yourself is what we're asking that person to do for us. And this is where the duties and responsibilities really come into play. Today, we're very lucky to have a wonderful co-presenter. Her name is Sophia Alvarez. She is the director at the Colorado Office of Public Guardianship. Her information you could see on your screen. It comes with a wealth of information, and she will go into what is legal guardianship and conservatorship and give you wonderful nuggets of information today for you to consider as you're working on your advanced care planning. So Sophia, welcome. Thank you so much for being here today. And I will go ahead and mute myself and turn my camera off and let you go ahead and take the lead on what is legal guardianship and conservatorship, and just let me know when you would like for me to move forward on the PowerPoint slides.
Thank you. Thank you for having me. And let's see, I think you can move to the next slide. We'll be discussing legal guardianship and a little bit about conservatorship and how that's different from legal guardianship. So what is legal guardianship? It is a court process. So guardians are appointed by a judge and overseen by a judge. Oh, I just got a message. It's hard to hear. Give me 1 second and I'll see if that's on my end. Please tell me if that does not help. Let's see. So guardians are overseen by a judge, and the judge is the individual that determines if a guardianship should be in place. And typically, legal guardianships can be put in place for an incapacitated adult or for minor children. So the court is who determines that an individual is incapacitated. A person has to be determined incapacitated before the judge moves on to the next step of saying that who there needs to be a guardian and who that guardian will be. Um, Regarding an incapacitated person, what does that mean? So, the incapacitated definition under the Colorado Probate Code is defined as an adult who is unable to effectively receive or evaluate information, or both, or make or communicate decisions to such an extent that the individual lacks the ability to satisfy essential requirements for their physical health, safety, or self care, even with appropriate and reasonably available technological assistance. So, when the court is determining whether an adult is incapacitated, they do review medical documentation. So, typically, a medical professional has written a letter to the judge indicating why they believe someone is incapacitated. Um, and also, there may be a medical professional may have completed some sort of capacity evaluation to determine if an individual is incapacitated. So the judge reviews that information. The person who is alleged to be incapacitated, they have a right to have an attorney represent them at the court proceeding if they disagree that they need a guardian. So there is evidence put on to the judge, and then the judge determines whether there's enough evidence to show that the adult is incapacitated. At that point, the judge then says they are incapacitated and they need a guardian. Then the court will determine, if the proposed guardian is appropriate to serve in that capacity. And today, I'm talking mostly about guardianship as it relates to adults. As we mentioned, there can be guardianships for minor children, and those are handled a little bit differently, but the process, having a court hearing and a court determination, are similar. We can move on to the next slide. So, what does a guardian do? What are they responsible for? So once the court determines that an adult is incapacitated and that they need a guardian to assist in legal decision making, the court appoints that person and says this person is the guardian and they have authority because of the paperwork that the judge signs. They have authority to make legal decisions for the individual. Um, it's a very significant decision, in my opinion, when the judge says someone needs a guardian, because you're essentially taking away some of the individual's rights to make decisions for themselves, and you're putting those decision making abilities onto another person. So, because of that, guardians are um, considered a fiduciary. So that means that we have a duty to act primarily for the benefit of the other person in matters related to which gave rise to us being appointed. So, as a guardian, while the court is telling you that you have the authority to make decisions on behalf of this other individual, as a guardian, you are still supposed to consider the wishes and desires of the individual when you are making decisions on their behalf. And in the court proceedings, the alleged incapacitated person, once they're deemed incapacitated and in need of a guardian, the court calls them a ward, WARD. So you may see that language in our slides. I try not to call a person that I serve as guardian for a ward because I feel that that's a very legal term, and I like to call them my client or my person. But we can make whatever legal decisions the court has indicated we can have authority for. So in the court proceeding, the judge will sign an order, sign letters that basically say this person is now the appointed guardian and they have the authority to make decisions on behalf of this person. And there can be full guardianships. And so typically, um, some examples of what a guardian can make decisions about are: where is someone going to live? What kind of medical treatment should they be receiving? They also have a responsibility to obtain or maintain any state benefits or federal benefits for the benefit of the person. So there's a lot of areas that a guardian can make legal decisions for on behalf of their person. Next slide, please. Oh, so continuing with what are the responsibilities of a guardian. So as I mentioned, we can determine or make a decision regarding where they're going to live, any sort of treatment, medical treatment, other services that they may need. You know, if they want to take classes, if they want some vocational training or assistance with that, we can also make decisions to have them be a part of programs like that. We can also we have a duty to keep clients' information confidential, and we can only release that if that's going to benefit the client. So, you know, as an example, maybe your client needs a surgery or medical treatment. It's likely that we would consent to releasing what medical, you know, prior medical records and documentation that we have, so that the doctors can review that and make a good decision on what our client needs. But that doesn't mean that we just release any information anytime. So even if a client that we may serve as guardian for, they might have family members that, you know, want information about the client, and there may be situations where the guardian may not provide information to the family members because their client requests that they don't release information to a family or any other person that they don't want information provided to. So um, uh, we can also assist and make decisions regarding end of life matters. Um, it usually part of like our best practice is to not just include the client and know what their wishes and desires are, but also um, you know, really talk with them and make sure, you know, if they're able to communicate with us, you know, these are kind of the decisions that need to be made and what are your preferences. We always want to um, um, we always want to do what the client wants, as long as it doesn't interfere with their health and safety. So that is a major duty of a guardian. It's to basically uplift the client and help ensure that they're meeting whatever goals and desires that they have. I saw real quick a question about voting. Unless the court has in that paperwork said this person can no longer vote, a person under a legal guardianship still has the right to vote. And as a guardian, you can assist them and, you know, um, in requesting a ballot or something like that. You shouldn't be voting on behalf of your client, but if they're able to tell you a preference or able to fill out the ballot, then they can certainly do that. And a guardian could then take that ballot and drop it in the ballot box. That would be appropriate. Um, One of the points here is to maximize independence in the least restrictive manner. Again, that's something that a guardian should be doing always. So, you know, if maybe someone's been hospitalized, but they are medically safe now, they're at a point where they can be discharged. A guardian should, you know, be assisting the process to get that client moved out of the hospital and into the best appropriate place for their needs, whatever that may be. And that could be back in the community, that could be in their own apartment or their house if that's where they were prior and it's safe for them to go back there. We want to, you know, maximize their quality of life, right? So if they can be in the home with some home community-based services, we want to try that first. And, you know, until it really becomes a safety issue, we want them to be as independent as possible, no matter where they are. And that's what we mean when we say least restrictive. We don't want to put someone in an institution or in a nursing home if that's not really what their needs are, or where it would be appropriate for them. And then guardians, as I mentioned, it's a court process. So every year, guardians have to complete a report to the court, and basically give information as an update. This is how often I've seen my client. These are the medical issues or mental health issues, or these are the educational and social activities that they're doing. We just kind of the court wants to make sure that a guardian is doing their job, seeing their client and making sure that their client is safe and healthy and having a good quality of life. And then there is a note about a guardian can act as representative payee. We don't do that at our office, but a representative payee refers to the Social Security Administration when someone receives benefits from Social Security. The Social Security office will appoint someone as a representative payee. So that is something that a guardian can apply for to the Social Security Administration, but it's up to Social Security Administration to say whether you can be a representative payee or not. And in Colorado, there are some decisions that a guardian absolutely cannot make and just do. And those are related to mental health institutionalization and substance abuse treatment. So I think a lot of times people think a guardian can, just call up and say, hey, I think my person needs to go to um, Fort Logan Mental Health Institute, and that would just happen. But that's not the process. There are two court processes, each for mental health institutionalization and then one for substance abuse treatment. So a guardian can assist in those court proceedings if they think that's what's best for their client, but a guardian can't just make that happen, and we can't force them into substance abuse treatment if they don't want it. Next slide, please. Okay, so conservatorship, it's similar to guardianship in the sense that it's also a court process and that conservators are appointed and overseen by the court. Again, they can be put in place for an incapacitated adult or minor children, and it follows the same process as determining for adults, are they incapacitated? If there's enough evidence that someone is incapacitated, then at that point, a judge would say, okay, then this person needs a conservator appointed to assist them. And a conservator is different than a guardian in the sense that a conservator is responsible for protecting money and property of the protected person. So a guardian is basically making or has authority to make legal decisions based on the person. So medical treatment, anything that affects the person themselves. Conservator handles the finances. Okay, so it's different here in Colorado. So those are very different processes, and each has different responsibilities. Both positions are considered fiduciaries under the law. So as I mentioned with the guardian, a conservator has to serve their person to the best of their ability and to what benefits them. And so the conservator can make decisions based on protecting a person's assets. If they have, a certain amount of money in checking accounts, if they have stocks and bonds, they may have a house, they may have some vehicles. So the conservator is responsible for the estate of the person. And the estate is defined as real and personal property, tangible and intangible, and includes anything that may be the subject of ownership. Sorry, my screen's a little cut off. So guardian takes care of the person, conservator takes care of the person's estate, assets, and money, things like that. Next slide, please. So what are the responsibilities of a conservator? So their responsibility is to marshal and protect assets of the person. They may have to obtain appraisals of property, make sure that assets are protected in the sense of, they're insured, that they are kept up, in good repair. So you need to protect from any potential losses. They can also receive income for the estate, and they can make appropriate disbursements, monetary disbursements from the estate. But they do have to obtain court approval before selling an asset. And they, like guardians, have to report back to the court on a client's assets and anything that they have, any income and any disbursements, all of that is provided to the court, so the court can keep an eye and make sure that the conservator is acting as a fiduciary and acting responsible with the client's estate. Next slide, please. So, when is legal guardianship or conservatorship appropriate? So as we mentioned, for an adult, that's when they lack decisional capacity, or they're incapacitated. And at this point, this would be an individual that, can't take in the information about a medical situation, and therefore has trouble making appropriate decisions for their own medical treatment. And it could be an incapacity, I should also say, could be due to cognitive diagnoses. So an individual could have dementia or a traumatic brain injury. A person could be incapacitated and unable to make decisions because of an intellectual or developmental disability. Could be due to a significant mental health issue. Could be due to substance abuse issues. So, a person could be very young and be unable to make these decisions. And that means at that point, they are unable to make any medical or financial advance directives. So someone has to have capacity when they are making those advance directives um, in order to be followed. So if someone becomes incapacitated and they haven't completed their advance directives, then if there are questions about capacity and whether this person can make good and appropriate decisions for themselves, the only recourse is then to go through the probate court. And at that point, maybe a guardianship or conservatorship is determined to be appropriate to assist an individual. But that that is why I think Maria and her organization really wants you to be able to complete those advance directives in advance, because then we know what you want to happen, what your decisions, what your preferences, what your wishes are, as opposed to if you've become incapacitated and the court appoints a guardian or conservator, and depending on the level of incapacity, you may not be able to share your wishes and preferences at that point. And then, the guardian and conservator are supposed to follow certain, guidelines to help determine what is good for you, as far as, what preferences you may have had a long time ago or what you've told people. But those decisions are going to be left up to the guardian and conservator. Excuse me. So who may not know exactly what you want. And so if you can, I think it's always good to do those advance directives when you have capacity. Excuse me. I think we can go to the next slide. And Maria, you may have to tell me when I stop talking and you start, because I don't see the slide numbers.
No problem. I'll let you know.
Okay, all right. So I think I saw a question about what if someone's capacity changes, or I think I saw something about can a guardianship or conservatorship be revoked? So as a guardian, it's your duty to monitor your client for any decline or any regaining capacity. So um, earlier I said that a guardianship could be a full guardianship. So a guardian is making all of these decisions, or a lot of these decisions. If your client regains capacity, which could happen depending on what brought on that incapacity, um, it's your job as a guardian to go back to court and tell the judge, excuse me, that your client has regained capacity. And in doing so, you need to have your client evaluated so that, again, there's medical documentation or a medical professional saying, yes, they have regained capacity in this respect, and they can now make, their own decisions related to where they live, as an example. So you can have what's called a limited guardianship. And that means that the court determines a guardian is needed for these specific types of legal decisions, but the client has enough capacity to make these types of decisions. And so they retain that ability to make decisions related to those areas, and the guardian can only act on decisions in these other areas. So that's a good question. Also, if a guardian or conservator are not doing their job, if they're not filing the paperwork, or if someone thinks that they should be removed, and a different guardian be put in place, that can happen as well, and that goes through the court process as well. Hopefully, I answered the question that was being asked. Um, so how is guardian and conservatorship different from advanced directives? So sorry, I kind of touched on this at the slide before. So durable power of attorney is a legal document, and that's where you name a person to act on your behalf, and that could be related to healthcare decisions or financial decisions, and that's for if you become incapacitated. So you have capacity right now, and you decide I'm going to complete this legal document. And as an example, say I may have my husband. If I become incapacitated, I'm going to say my husband can make these decisions for my medical or my finances. Um, again, that's when I have capacity. And the person who is named, um, they're usually called the I'm trying to, now the the I'm so sorry, the term attorney in fact. They can't act or make decisions for you unless you become incapacitated. A living will is another advance directive, and that is another legal document, and you basically lay out, you state what healthcare medical decisions that you want to happen if you become incapacitated. So that may have very specific information, like I don't want to be on a ventilator, or I don't want this, or I do want this. Um, and that is basically the document that says this is what I want. It doesn't necessarily name someone to act on your behalf, but it's you expressing your preferences and what you want. And again, you can do that while you have capacity. So when a guardianship or conservatorship comes into play, that is after you've been deemed incapacitated. And if you don't have these other documents, that the guardian or conservator is relying on other information if you're unable to communicate what you want. Um, so, in my opinion, it's good to have these advanced directives, even if your guardian or someone ends up being put in place. They at least know what your preferences are, and it's their job, their responsibility to follow your wishes and desires as you stated when you had capacity. Excuse me so much. Next slide, please. Do we have the next slide? Or my computer might be stuck. Best practices. All right. Okay. So best practices for Guardian. There is an association, a National Guardianship Association, that basically has been around for a very long time, and they have established standards by which a guardian should act. So there are ethical principles that a guardian should follow. There are standards of practice that a guardian should follow. Um, and a lot of the standards and best practices that a guardian should be following are really outlined really well at the National Guardianship Association level. Their website is very informative. It walks you through what's a guardian. There's educational webinars and classes on the website as well. And so, part of the best practices that we talk about is, of course, as I mentioned, the guardian, can coordinate services for your person. So they can select, you know, professionals to come in and assist you. They can help select and coordinate your medical treatment, your team. Uh, Oftentimes, a client has become incapacitated. Usually, there's a team of people, right? They may have a counselor, they may have a medical doctor, they may have a psychiatrist, there may be case managers, other people that are involved, family members. And so the guardian is kind of supposed to help coordinate and make sure that everyone's doing what they need to do to make sure that their client is getting, the best care, the appropriate care, um, and that it's all professional, and there's no, issues with the care that you're receiving or services that you're receiving as well. As I mentioned several times, a guardian is to learn about the word wishes, desires, goals, and it's best practice to create an individualized guardianship plan. And that can include anything and everything. I don't know if you've heard of the term, well, it's on the last slide here, person-centered planning or person-directed planning. Um, if the client that you're serving can communicate and express, however they can express and communicate what they want, it should be our job as a guardian to advocate for that, assist them in advocating. The person is always included in decision making. That means even I, as a guardian, um, if my client needs a medical procedure that, they don't want, it's my job to get all the information about that medical procedure and talk to my client, say, okay, this is what's going to happen. This is what could happen if we don't treat it. These are the pros, the cons. These are the risks, the benefits. And, you know, I take into consideration how they feel, what they think about that. We talk about that. And so it's really important to include that person, right? Because they're an individual. Even if they have some sort of incapacity, that doesn't mean they, can't make any decisions or don't have any, wishes or desires. So it's really important that we include the person and that we kind of, as I said earlier, lift them up, advocate, for them, but have them um, lead the process of, you know, explaining what they want to do, and that could be medically, that could be educationally, like I said earlier, vocationally, social. As an example, I had a client that he was he had difficulty communicating, but I was able to learn, talking with him, that he used to love fishing. And at this point, he was in a nursing home in a wheelchair, couldn't get around very well. But once I learned that, I talked to the facilities person and said, hey, he likes fishing? Is there, something that we could do? And it turns out that they did annual fishing outings with some other nursing homes. And so he was able to go and he was so happy, So, it's important to just talk to your person and learn about them. What did they used to do? What were their jobs? What were their hobbies and things like that? Because I think that's a good way of, being able to get them to tell you what their preferences are, even if they can't always very explicitly state it. Next slide, please. Okay, and so these, again, best practices, I've kind of talked about a lot of these already. We talked about maximizing the ward's independence in the least restrictive manner. So again, if they can be in the community and be safe and maybe have some services come into them, we want that to happen instead of just, putting them in a facility or institution where that doesn't really match where they're at or what they need. Again, that annual reporting and again, that's evaluating your ward to see if they've regained capacity and notifying the court of that. And I kind of mentioned a little bit ago about the medical treatment. When consenting to medical treatment, the guardian should make decisions based on informed consent. And so that's like any of us have to make a decision based on informed consent. So that means we are learning all of the information, like I mentioned, the pros, the cons, benefits, risks. And we need to know all of that to be able to make a good informed decision about should we move forward with this procedure or not. So that's very important because we're making really important big decisions for individuals, and so we want to make sure we really know if something's an appropriate way to proceed or not. And yes, the guardian stands in the place of the person. So whatever your client, would normally have access to, medical records, information, any of that, a guardian is able to, should be able to, and I believe that's, in the court paperwork as well. They should be able to have that information and access that information. And sometimes you just kind of have to educate people if they don't understand guardianship. Next slide, please. Oh, I get to talk a little bit about our office, the Colorado Office of Public Guardianship. So our office is a pilot program that is focused right now on Denver County residents. In 2023, I will provide a report to the General Assembly. And at that point, the General Assembly will determine whether our program continues and expands or if the program will be discontinued. So the way our office works is we have 4 public guardians, and each of them have a caseload of about 20 clients, or will. We're not at capacity yet. And we will be adding an additional public guardian this summer. So I'm very excited about that. That means we'll be able to take on a few more clients. So by statute, our office serves adults 21 years of age and older that are indigent and incapacitated, and they have no other person available or willing to serve as guardian. And we have a referral process that you can do online, or you can call our office, that office number that was included on the slide with my information, and our staff assistant can assist you in completing a referral. And the referral process is to ensure that we are meeting our statutory requirements of serving adults 21 years of age, indigent, and incapacitated, and that there's no one available or willing to serve as guardian. Next slide, please. And I'll just give you a tiny bit about some specifics of our office. Right now we have, I believe, 42 active guardianships, active clients that we serve. And we have many referrals still in the court process right now. But the clientele that we serve, all the capacities that I mentioned earlier, um, cognitive diagnoses, mental health issues, diagnoses, intellectual or developmental disability diagnoses, uh, uh, substance abuse issues. We right now serve all clients with all kinds of incapacities as long as they fit the other statutory criteria. And if you have any questions or information beyond this presentation today, feel free to reach out to our office. And we have a general office email, info@colorado-opg.org, which is monitored daily, Monday through Friday. And then our website has additional information about our office and kind of how the office came about and how we're hoping to expand statewide once the General Assembly hopefully continues our program. Maria, I saw some questions and I didn't know if we wanted to try and do those now or at the end. You tell me.
Yes, we could go ahead and address some of those questions because I think they're pertinent to the things that you were discussing.
Okay.
So some of the questions, go ahead and give any feedback to any of the questions that you want. The ones that were included in the Q&A, I have replied to.
Okay.
But if there's any other questions that you see and want to expand on any of the answers, please do so.
Okay, let me see. Voting, we talked about that. Okay, if you have separate people appointed as guardian and conservator and they disagree, who decides? I would say it kind of depends on um, what the issue is, what the disagreement refers to, if it's referring to something that the guardian has authority over or if the conservator has authority over. So whoever has the authority is the one legally who's able to make that decision. Now, if someone disagrees, if a guardian conservator disagree with each other, or a family member disagrees with the guardian conservator, you're correct. You can always file a letter or something if you can't get an attorney, and send something to the judge and kind of explain why you're questioning someone's decision. And again, depending on the judge and the situation, the judge may set that for a hearing. So all the parties would need to appear for a hearing, and the judge would, probably not necessarily make the decision ultimately, but the judge may say, okay, I've heard all of this. I agree with, the guardian, and the guardian has authority. The guardian can make the decision. The judge can do any number of things, but yes, you can always have it reviewed by a judge. Let's see. Okay, that was you. Oh yeah, thoughts on supported decision making and how it interplays with guardianship. So um, I strongly believe in supported decision making, and I think that is something that's often overlooked. So that is basically there's not going to be a guardian or anything like that. It's basically that this person may have an advocate or team um, uh, helping with information. They're not making decisions for this person, but they're helping that person with information or helping them advocate for themselves. I strongly believe in that, and I wish we would do more of that before going to the step of guardian, because as I mentioned previously, a guardian ends up taking, being able to make a lot of decisions that the client might still be able to make. So I don't know if I'm really answering your question, but I do think we need to be definitely try and support decision making with an individual before we just say, oh, no, they can't make decisions. We just need a guardianship. I feel like a guardianship should really be that last resort. Um, and so, like, when we get referrals to our office, um, I look very closely at that referral to make sure that it does. I'm not the decision maker. I don't decide if someone's incapacitated, but I look at it saying if they're incapacitated, does it rise to the level that they need a guardian? Or could it, could this individual maybe just need a representative payee and they could be okay and live in the community? Or could they live in the community with services? So, yes, I think guardianship should be a last resort, and we should be trying to assist people in advocating for themselves rather than just deciding we need to make decisions for them. Let's see. Okay, I think that covered all the things in the chat.
We do have a question in the Q&A. Does having a different guardian conservator serve as well as systems of check and balances, or is it typically more of a problem? So I think they're referring to having either co-guardians, co-conservators, or a different person serving as a guardian and a different person serving as a conservator.
Sure. Yeah, so every situation is different, of course. And yes, you're correct. I believe that having different people serve in those positions is to help with those checks and balances, and just make sure that one person can't just make all the decisions about everything for someone without. And again, they would have support oversight, but I think it just helps to have, you know, different individuals making different decisions and having the different authority. Um, you know, Typically, I think it just really depends on who's appointed as guardian or conservator, what the dynamics are like, because I've seen it work very well. Sometimes family members can be co-guardian or co-conservators, or whatever the situation is, and it works very well. But like anything else, there are situations where it doesn't work very well because of whatever the dynamics are. Um, and so with that, it's hard to, you know, I wouldn't state a preference or anything like that, but certainly if there are any issues or concerns, like I mentioned earlier, take it back to the judge, um, and the judge can kind of help mediate that or figure out who really has the authority to make some certain decisions.
And also to add, these are conversations that we need to have prior to us needing guardianship and conservatorship if we have decision-making abilities, right? It's a little bit different for our folks that have developmental intellectual disability since birth, but those that are not in that community, we have the ability to talk to our loved ones and have a plan in place, what it would look like if I need guardianship and conservatorship, and who I want to nominate for those roles, and how I would want that to look like. So that way you actually have a plan, and everyone that would be part of that plan has an idea how things need to look. Working in community, I've had situations where families are very strategic in what child helps with what based on their expertise, based on how well they do with the medical aspect versus the financial aspect. And that's how they focus on it, versus other families wanting one person to be spearheading the plan, and then having alternates and backups to step in. So it's a very much, I would say, needs to be a conversation for families prior to actually having this as a need. So that way we are respecting someone's preferences and we already know what we need to do, right? Because guardianship and conservatorship, the court appoints who those individuals are, not the individual. And this is the difference between the advance directives and the legal aspect, right? The advance directives, we nominate people, we appoint them, we tell them how we want to be supported, versus guardianship and conservatorship. It's in law how a guardian could assist, how a conservator can assist. So it's a very different roles, and it's managed very differently. So when we're looking at advanced care planning, that's why I'm a very strong promoter of looking past the medical and really looking at your situation as a whole. So what are all the spheres that are impacted when something happens to us, whether it's a medical crisis, a car accident, or whatever have you. So I think those things really do make a huge impact. One of the things that we often have to deal with, especially in the aging ecosystem, is I don't have a loved one, I don't have a family member to assist me. So how do I create a plan for myself? There's private case managers that do this for a fee. One of the reasons why I love having Sophia here is because of the pilot program for individuals that do not have that support system. And it's something that is very much needed. So not only do we need to have the conversations, we need to have systems in place to make sure that everyone has equitable opportunity to have these safeguards in place, especially if in different communities, we have individuals that have outlived all of their other family members, or excuse me, their chosen family is no longer alive and they don't have any other type of natural support. So what does that mean for them? So this is why these conversations, we need to have them often, and we have to figure out what that looks like for us, whether we have those natural supports or we need to look at maybe an organization or individual private case managers that do this type of work for a fee. Sophia, thank you so much. I do highly appreciate all the work that you do and the expertise that you bring into this subject. So now we're going to shift gears and I'm going to wrap things up for us. So I wanted to give you a taste of what to expect when you're filing guardianship and conservatorship for your person, right? Whether they're a friend, they're your loved one, whatever relationship that person is to you. There's some certain things that you're going to have to do. And one of those things is you at least need to be 21 years of age or older to be able to file the request to be either or both. You need to be able to pass and have a clear name-based criminal record. So they're interested in knowing that you haven't exploited individuals, that you don't have any type of criminal background that would put in jeopardy someone's safety and someone's assets. You need to also be willing and able to follow best practices as well as the duties and responsibilities, and be able to advocate for the person that you're requesting guardianship or conservatorship for. The court process, I have oversimplified this in 4 stages. So it's a little bit easier for individuals to understand a large overview. Whether it's guardianship or conservatorship, they're different forms, but the process is pretty identical. So the first thing that you need to do as the person that is trying to become either the guardian or the conservator is submit the initial petition. The initial petition is a set of various forms where you do have to include the background check, where you need to include copies of your credit report. This entire packet needs to be submitted to the county court where the individual that needs the legal guardian or the conservator lives. So if you live in Denver and the person that needs the assistance lives in Adams County, then you have to go through Adams County. Once you submit that initial petition, during that initial petition, there is a filing fee that you need to submit. If you are facing financial hardship, there is a waiver that you could submit, and then the court decides whether you need to pay that filing fee or not. So if that's a barrier to making that initial request, there's a way to remove that barrier. The next area is the notice and service. Once we've submitted that initial petition, the court is going to give us a hearing date, and now it's our responsibility to go ahead and notify all interested persons. So this is a spouse, children, any family members, anyone that has lived with our person that knows the person well and would have an interest in making sure that that individual has the ability to say yay or nay that our person needs a legal guardian or a conservator. So once we have notified everyone, then we have the actual hearing. This is the actual court date where the judge reviews the process and they decide. Between the hearing and the initial petition during the notice and service, the court appoints a visitor or a guardian ad litem, depending on the situation, and they go ahead and research and review. Because this process is a very important process, like Sophia said, we are petitioning to take away someone's right. So the court wants to make sure that they review everything thoroughly and that there is incapacity. And that's why during the notice and service period prior to the hearing, there's a court-appointed guardian ad litem or visitor that will visit the individual in question of needing the legal guardian or conservator. So at the hearing, that's where we have the judge, they have all the information and they decide whether a guardian or conservator is needed, and if the person that submitted the petition is apt to be either the guardian or conservator, whatever the petition is. If the judge indeed says we do need to appoint a guardian or conservator, they complete an order. And this order indicates the responsibilities that the guardian, the conservator has, along with what they need to do and how they need to then file reports. And at that point, we go into the post-appointed fillings. And these are a series of documents that need to be completed to make sure that the individual that is appointed is doing everything that is needed, as well as following up with the reports as the court assigned. So this is an oversimplification of the process, but this is what to expect. Depending on the type of guardianship or conservatorship that you're seeking, the time span varies. When we're requesting an emergency, either guardianship or conservatorship, the process is treated in a shorter span versus a typical legal guardianship or conservatorship request. So I wanted to give you an idea of basically what are all the different areas where there's a fee associated. So we've already talked a little bit about the filing fee. Here's links to those forms that I spoke to you about. Since you have to service individuals, there's a lot of copies that you'll need to make. There's a certification fee. So this is typically usually around $20. And then there's a per page copy fee. So those are all fees that need to be paid. And also this is more for your information. Next, here's the information where you would have to get your background check and your credit report to include in that initial packet. All of these are hyperlinked, so you could actually go and do that process. Lastly, I wanted to include basically a decision tree to see if legal guardianship is the right situation for you. And here we have this definition that we have seen throughout to ensure that you fully understand what incapacitated means, because of my work with older adults, sometimes if a person can't hear, obviously they can't make decisions because they can't hear what is going on. But if we have the technological assistance of a hearing aid, and with the hearing aid, they're able to hear, and now they can make decisions because they could actually hear, then they are not incapacitated. So that is just a simple example of how technology could change someone's abilities. And once again, we want to use the least restrictive method possible. So we should be looking at legal guardianship very carefully, because once again, we're talking about taking someone's right away to make a decision for themselves in that area. I've also included resources for you. All of these are hyperlinked. So please, when you get the email with the PowerPoint, feel free to click on any of the hyperlinks to get any of the resources. Thank you so much for joining us today. Thank you, Sophia, for being with us today and supporting folks in their advanced care planning journey. It is 2:01, so at this time, I will go ahead and wrap things up for us. If you have any questions, my email will have both Sophia's information as well as myself, and you will have access to the recording. Thank you so much, everyone, for joining us. We hope you have a wonderful day, and join us Monday for our last advanced care planning webinar on last will and testaments. Thank you so much, and be well.